Hey, good evening and welcome to the July 11th, 2024 Board of Directors meeting. We'll call the meeting to order at 6:01 p.m. Our land acknowledgement and anti-racism statement can be found online. Roll call tonight. Everybody's here and Stu will be joining us via Zoom and he is currently online. Can we get a motion to adopt the agenda?
I would like to amend the agenda. I request that the Board of Directors ratify the decision of the executive team to approve an additional $27,401.28 in funding for Project 9723.05 tennis court resurfacing be added to the agenda.
Excuse me, I can't hear her.
Oh, I'm sorry. Would you like me to repeat it? For Project 9723.05.
Does she need to read it again?
Yes.
Yes. If you can read it
Okay, I'm sorry. I request that we amended the agenda to include ratification of the decision of the executive team to approve an additional $27,401.28 in funding for Project 9723.05 tennis court resurfacing.
Second.
All in favor of amending the agenda? AJ? Stu? Yes, okay, it's unanimous. It's unanimous. Sorry, I'll try to remember. Oops. I'll try to remember to get closer to, but not too close. Okay, the amended agenda has been adopted. So moving on to item number 2, announcements. Any announcements tonight? Rob?
Yeah, I just want to announce that the period is now open for those who would be interested in applying for one of the open board ACC and N&E positions. There are some open seats. That time period is open until 4:30 p.m. on September 3rd.
Thank you. Thank you, Rob. Any additional announcements? Timey?
I just want to remind everyone that the Valley Fair is this Saturday from 10 till 3. There's lots going on. We have vendors. We have a some cirque performers. We have face painting. There's games going on. We have dino races. We have all kinds of things going on. So please come down, buy some stuff from the wonderful vendors that we have down there and have a great time. There will be food, beer garden. Oh yeah, don't forget the beer garden. So come on down and have a great family day. Oh yes, there is. Thank you. I don't know if you heard that, but there is a car show going on. And so there's probably going to be a couple of really interesting cars that you can go around and look at.
Any additional announcements? Rob?
I failed to bring up the candidate applications. Those can be picked up in person at the Welcome Center. And there's also a link on the Sun Valley website where the candidate application can be downloaded. Once filled out, they need to be put in an envelope in itself made out to the NE chair and then brought to the Welcome Center where they'll be date stamped. Thank you.
Yep, you got it. Did everyone hear that? Okay, good, good. Any additional announcements? Okay, hearing none, we're going to move on to property owner comments. 15 minutes total, 3 minutes per person. Do we have any property owner comments tonight? Nancy, you're up first.
Nancy Alionak, 4 Sandalwood Circle. The reason we have this antique equipment hanging around the table and back there is because it discourages member comments because they cannot do it remotely. A new system is not very expensive, maybe a few $1,000s. I actually priced one. And that is nothing for a $6 million outfit. like Sudden Valley is. It would help sharing information with your shareholders. And that's very little to keep your shareholders involved. It also would reduce the obnoxious noises this thing will make, which I won't demonstrate at this time. Part 2 of the comment is measure 3, an amendment to the bylaws to change appointed directors' terms. That amendment would allow a appointed director to fill the term, the full term of the person that it was empty. And what that does is put a target on any newly elected board members who have 3-year terms, because that's a real plump. You can threaten to sue that person and until they quit, and then it will be as if they were never elected. That is what the amendment does. And considering this group is particularly suit happy, you can expect, if you're a new member of the board elected with a 3-year term and you have any differences with board majority, you're toast, because you will be harassed out by lawyers. I mean, we have a perfect example later on today in the closed session. And you'll eventually leave because it will be too expensive. And now I'll go back to the part about why we need to get rid of these. It's because they don't catch sound very well, and they can be tricked into making annoying noises, and it would be a really good idea to get new equipment before the AGM. Thank you.
Thank you, Nancy. Hi.
Liz Vidal, Rocky Ridge Drive.
You get close to Mike, sorry. It's really hard.
You don't want to hear me. Okay, so I'm just going to read you an email that I wrote, and I thought I had sent it, but I hadn't, so I will read it now, and you guys will have the pleasure of reading it later. I just want to say, I've lived in Sudden Valley for 7 years. During that time, I've met some of the most generous and community-minded people I have ever known. I have also seen some incredibly bad behavior. And that bad behavior, unfortunately, appears to only be worsening under this board majority. Until this board, I had never imagined that they would use the Sudden Valley attorney to threaten action against a fellow director for speaking her mind and for being unwilling to sit idly by while the majority breaks our bylaws, ignores a community advisory vote, approves minutes that do not accurately reflect board meetings, and allows the general manager to treat her with contempt and disrespect. I thought that when the board president asked me to remove a post from Facebook in which I had accurately quoted him, I had seen it all. When I declined to take the post down, the response from the board president was hard to fathom. In light of the recent board majority decision to use our Sudden Valley attorney, not their personal attorney, but our attorney, to quash a fellow director from representing those in the community who elected her, I can only wonder if individual homeowners should also be concerned about retaliation if they exercise their right to speak freely in this community. Additionally, This board majority has not only spent our funds on having our attorney write a ridiculous letter to intimidate Director Volt, you have also wasted our time and our money putting in place a grievance process that you obviously have no intention of following, in spite of giving the community your word that you would. You are the board of an HOA. You are serving as volunteers in order to listen and respond to the needs of our community. Your positions on this board require you conduct business in the best interest of the entire community. Being a board director does not allow you personal privileges, nor should it. In fact, your positions mean that you answer to all of your community. And your community, like your fellow board directors, have every right to express themselves as long as they do not interrupt or interfere with conducting the business of Sudden Valley. Director Volt has done neither.
Thank
These
you.
attacks must stop.
Thank you, Liz. Any additional comments? Please.
Reg Mulligan. Just some comments.
Yeah, you.
Name, please.
Sorry, Reg Mulligan.
You almost have to eat it.
Like you have to hold it. It's too heavy for that. Oh, good. Sorry, guys. Reg Mulligan. I just had some comments about the proposed bylaw amendment for short-term rentals. Just wondering, is it Sudden Valley's intent to use member resources to do what Whatcom County's job zoning enforcement is? Is there data to warrant and support the action? How do the number of parking and noise complaints for STRs compare with other homeowners? Will Sudden Valley honor slash the grandfather legacy clause provided by Whatcom County? And I think, second here. That's really the main points. Just I think there's a lot of concern, likely from people who have STRs that are near them. And I think it's a situation where I can completely understand it could be a problem for others. And trying to manage that is a good thing. But whether it is a short-term renter or a terrible permanent owner are two different things. I think it would be good if people spoke to those people and see if they could manage that sort of thing. I think we should all take a minute and pay closer attention. These short-term rentals often employ a lot of people in the community to manage them, clean them, and deal with them. And just some things to consider. Thanks.
Thank you. Appreciate your time. Can we get your name again? We didn't hear it clearly. Thank you.
My name is Michael Roney. I'm been a resident of Sudden Valley since 1984. We purchased our home in 1987. I'm a big supporter of short-term rentals because between 1984, I met my wife here in a short-term rental. 86, we were married, and our children grew up here till they went to grade school. We live in Vancouver, and they told all their friends that Vancouver was just the place where they had to go to school, but they lived in Sudden Valley. I'm a supporter of short-term rentals. We have done it randomly since we purchased our home. We did long-term rental once, and that turned out to be a nightmare. I really get it because when I retired in 2018, we turned our home in Vancouver into a VRBO home because my wife and I were traveling, and we were 6 months here, and then we traveled the rest of the time. And we went through all the pitfalls, we learned all the lessons, and I look at this amendment as something that I'm not really even, I would rather that you didn't go too far with doing anything on this. Instead, maybe just take a common sense approach. My experience with short-term rentals, most of it is really positive. The three things that are brutal, first of all, here in Sudden Valley, because I've seen it, is garbage. And that's really easy to resolve. We personally went and got two of the biggest bins that SSC has and we pay them $4 a month, that if renters forget to put it out on Friday morning, they do it for us. Secondly is parking. Parking has always been an issue. I have actually been a victim of that this year, where I parked my boat for 2 months waiting for a dry slip. And, you know, the general manager sent me a letter and I just got really lucky and found a spot. That's something that security does. So we don't really need to have more rules on that side of it. Oh God, I just lost my train of thought. I'm too old for this now. The parking, garbage, and noise. Yeah. Now, I have 3 teenagers, and in our neighborhood, they've all come to my door, knocked on the door, and we weren't around and they were making too much noise. We have already systems and rules in place to control that. One of the things that you may not be aware of is that the owners and the property managers of these short-term rentals here rate the guests. And if they break the rules and they make too much noise or they leave garbage all over the place, they get a really bad review and they're never allowed to come back. So the repeaters will not come back to Sudden Valley. That's an easy one. I don't know. I don't think you need to add a whole bunch of new rules. Maybe one easy solution would be to ask the property managers.
Okay, sorry, your 3 minutes are up.
Oh, are they up?
Yeah.
We'll ask the property managers to supply with their rules and regulations. Anyways, that's all I have to say. Thank you.
Thank you very much. Appreciate your time. Good evening.
Hello, my name is Bruce Shear, at 6 Bowline Court. I've lived here since 2000. I'm a retired teacher and a football coach and golf coach now, but I want to piggyback what Mike just said. I want to tell you a story, and I can make it short, I think. One of my football coaches has a sister that lived here, and he wanted to sell her house and she couldn't do it. So he knew my son would buy it. So my son bought it under the condition that he would refinance it after he fixed it up and give him half of whatever he made on the refinance, which was very generous. I never heard that before. Anyway, he did a beautiful job. The house before it was dilapidated. The garage door was half open and at a slant. And the weeds were growing. They had 3 cars in the garage and 1 in the weeds in the back. I mean, it was a mess. And anyway, he fixed it up, and it's one of the most beautiful houses in the neighborhood. In fact, all the clients that come in and use it just rave about it. Well, the noise, the parking, and the garbage is going to be an issue for anybody in the short-term rental. I just want you to know that a neighbor has been harassing him because of the garbage, and he's been paying a high school boy very generously to do the garbage. Well, he blew it this last week. And he put out all the recycle and everything out there. Of course, it stayed out there, but the bad thing about it is that lady who lived there died on her couch. She was there for 10 days, had bled to death, and nobody checked on her. And when we went into, the cats were living in there, the dogs were living in there. They never got to go out. It was a classic case of a hoarder, and it was stuff that high. And the kitchen was just full of pots and pans already filled and empty. So now it's a GM of the neighborhood, but he had a lady a couple doors down come up and put a brown bag on his he had a camera there saying some derogatory words, but he's, get your effing garbage, and it's continuing. And so what I did is I went and looked at the bylaws, and I hadn't looked at them since I bought my house. And it has the items that we're talking about. It has the items of garbage, keeping your house up, making it look nice. And even, and I have great neighbors. In fact, I think the realtors have sold 5 houses around me. And what they do is they brag about their neighbors. you know, the guys selling them, because all our neighbors, if somebody leaves their garbage can out, we put it back for them. Yeah,
Time's
I
up.
appreciate your time.
I'm sorry. I appreciate your time. Any additional comments tonight?
Hi, I'm Barbara Michelson Harder. I live at 172 Polo Park Drive. And I'm just getting used to coming to these meetings, and I did look up the agenda, but I did not know where to look for the proposed bylaw amendment, so I have not read the amendment on leasing. It sounds as if maybe the board is making some tighter rules on leasing. Am I right? For short-term rentals? Is that what's going on? So thank you. I appreciate
Well,
that.
the idea is trying to get some kind of control over it. What we need to do here, if they're going to be allowed here, is we need to have a way to monitor them and things like that. So that is kind of the idea behind the tightening of the bylaws.
And I agree. And I don't know what to say to these gentlemen, except it sounds like maybe you are an owner of a short-term rental who lives here, who also lives here. I think one of the problems is when the owners of the houses don't live here, or maybe they live in Bellingham, maybe they live in Seattle. And so there's no on property. It's too easy for things to happen, like the garbage. It's too easy for things to happen, like the noise. And I don't know if we have any rules, and I apologize again for not reading the amendment, if there's a rule for how many people can be in a house. I had the privilege of having my letter to the editor published this month in the paper, and I talked about a short-term rental that's on Western. And as I walked back from and I don't know if that belongs to any of you gentlemen or not, but as I walked back from the mailbox one afternoon at 4 o'clock, there were 7 cars. And they were 5 of them. I noticed them because 5 of them were white SUVs. That's a little unusual. And there were 4 parked in the driveway, side by side. There were 2 parked on either side of the driveway on the lawn, and then there was 1 in the street. And so I'm thinking, how many people are in that house? How many people are staying overnight? How much noise are they going to make just by virtue of the fact that there are a lot of people there? Did 2 people come in each car? Did 1 person come? I have no idea. But I think those are the things that hopefully I will go home tonight. I'll read the amendment that is going to be addressed. And I think those are some of the problems that residents that live next to these houses are concerned about. When people come here, they're on vacation. It's not everybody I know, but some people come. Look, I used to work in the hotel business. It was amazing what people would do to a hotel room because it wasn't theirs. They didn't care. The same mentality goes a lot of time for people coming on short-term rentals. It's just human nature. You know, not everybody, but just enough to make it a problem. That's all. So thank you for listening. Thank you, gentlemen, for listening.
Look at that, exactly 3 minutes. Thank you. Any additional comments tonight?
Hi, my name is Jerry Helpine, and I live at
Name again,
74
please.
Jerry,
Jeffrey?
Jeri, Helpine, Halpine.
Thank you.
Address is 74 Windward. And something that hasn't come up in the context of short-term rentals, but I think also applies to permanent residents here in Sun Valley, are speed limits. I'm really curious to know when the last citation has been issued in Sun Valley for speeding. Does anybody happen to know?
Sudden Valley security and staff are not allowed to do traffic stops, and we have no equipment to assess whether someone is speeding.
Okay, well, in the bylaws, it does mention that there are fines.
Yes, there are
for
fines.
speeding, but it sounds like there's
And
no
the Whatcom
enforcement.
County Sheriff has elected not to enforce non-criminal penalties within Sudden Valley's private property. So that's the state of affairs that you asked for.
Okay. Well, for anybody that lives in Sun Valley, you're probably aware that people do speed quite frequently. I think that's even more true for people who aren't from here and are living in short-term rentals. The speed limits are clearly posted, they're just not very well obeyed. We don't have sidewalks. There are a lot of streets with very low visibility, either because of turns or hills. I've personally almost been hit by a car. I did see a car or witness a car hit a fawn last year. It's a common occurrence. And it's disheartening to hear that even though we have bylaws that state that there are fines for speeding, there's no means to enforce those speeds. So it's laughable. It's admonishable as well.
There's no way to enforce it. There's a lot of issues with it, and
So that's actually.
Yeah, and on the other hand, I've heard that citations have been issued for people who leave their garbage cans out after Saturday. I've never seen a garbage can hit a person. If anything, they do obstruct people as they're walking along. But it seems almost ridiculous too that we would fine people for their garbage cans, but we're not fining them for speeding.
well, you see the difference. So you try to find somebody for speed on private property here and try to prove that in a court. You know, that's the problem. And we're having trouble getting the sheriff out here just for that same reason, because it is private property. We have been talking to them recently several times to try to, what we have to do is hire off-duty. We're 3 minutes.
I'd love to hear progress.
Real quick, we're
against
trying to
the
hire
issue.
off-duty for that reason, so we could set up some speed traps and things like that.
Yeah.
Try to see if they will come out and do that.
Great, thank you.
Thank you for your time. I appreciate it. Any additional comments? Okay. Hearing none, we're going to move on to item 4. We're going to move into closed session at 6:27 PM.
Motion to move into closed session?
Second.
All in favor?
Time again?
Unanimous. 6:28 now.
Thank you.
So we'll be in closed session and then back up right after that. All right, we'll call back in session at 8:24. Motion,
Motion to move to open session at
8:24.
8:24.
Second.
All in favor? That's unanimous. All right, coming out of closed session, we have the following statement to read. In closed can everyone hear me? Want to make sure, can you all hear me? Oh, is that better? Okay, thank you. Coming out in closed session, the letter from the SVCA attorney that was sent to Director Volt's attorney was discussed. The SVCA's attorney was present to clarify to all board members were present and agree at the same time that there was no threat or otherwise implied of any legal litigation against Director Volt.
Thank you all for taking the time to work through that. Appreciate it.
Excellent. Thank you very much. Moving on. We're moving on to one more time. No. Right. Right. Very good. So moving on to item number 5 is the consent agenda for meeting minutes from June 13th, 2024 as submitted, as well as minutes from June 27th, 24 as submitted. Any comments or questions regarding either of those?
I'd just like to make a comment, and it's to the board, because if you're looking at the minutes for Thursday, June 27th, there's things noted in there. We kind of got off topic, and I actually told Morgan that I would do the minutes. I wouldn't wish them on my enemy. It was a really confusing meeting. If you see anything in here, I added where there were items that we voted on. They were out of order. They weren't on the agenda, but we voted, we moved on them, and they're there because we did. So if there's any questions, please just reach out. Otherwise, can I get a motion to approve those minutes, please?
I move that we approve both minutes as submitted.
I get a
Second.
second? Who is that? Ray?
Rob.
Oh, Rob. Thank you, Rob. All in favor? Okay, that's unanimous. Okay, moving on to item number 6, the general manager's report.
Thank you. The first topic in my report this evening is vandalism. On Tuesday, July 2nd, SVCA security discovered that the gate securing the RV storage area had been vandalized. The mechanism that opens and closes the gate when an access card is swiped was broken, making it possible for anyone to open the gate manually. Security discovered this issue when a resident reported that his card wasn't opening the gate. This resident also reported that he believed his trailer had been stolen from the storage area. Security used a chain and padlock to secure the gate, and a notice was sent to all the people who rent a space in that area. The notice informed those renters that the gate had been vandalized and that security should be called when they needed access. Renters were also encouraged to check on their property and report any damage or loss to the Whatcom County Sheriff's Office as well as to SVCA. SVCA in turn reported the gate vandalism to the sheriff and let them know that renters might be contacting them separately. The gate was repaired on Friday, July 5th, and is now functioning normally. We have not had any follow-up reports of additional damage or loss. The next topic is election materials storage. The N&E committee maintains 2 storage closets. One is in the clubhouse and is mainly used during the election season. The second is in the community center and is used to store materials from the prior year's election. During the recent lock rekeying project, the lock securing the N&E closet in the community center was replaced with a standardized core, making it accessible to a few staff members who had a key for that area. SVCA's maintenance and facilities manager had clearly instructed the locksmiths working on this project not to replace that lock, but they made an error. We discovered this error on Tuesday, June 25th. The lock was immediately replaced that day. On July 3rd, I inspected the contents of the closet with Rob Gibbs, the chair of the N&E committee. Together, we confirmed that the locked cases stored in that closet had not been disturbed. All sensitive materials were exactly as they had been left by Unilect, our election provider, following the last election. Additional security. On June 20th, the Whatcom County Sheriff closed Lake Whatcom Boulevard between Lake Louise Road and Southern Court because of a major accident. This caused many drivers to attempt to detour through Gate 5, accessing it up Southern Court. After one driver ended up in the ditch alongside Southern Court, I made the decision to close that road to outside traffic. These road closures required that a guard remain at that site during most of the evening shift. To ensure that a guard was available to respond to calls made to security, a second guard was called in, resulting in overtime. Additional security was also on site for daylight hours on the 4th of July weekend. This allowed one guard to monitor traffic at the marina and other outdoor amenities, while the second guard responded to calls. Although security responded to many reports of fireworks, no violations were issued. This was because security wasn't able to catch anyone with the fireworks. Yes, they all ran away. Next, I'd like to update everyone on the status of our capital projects. The Area Z maintenance shop is on track to be completed in July. We've been waiting on PSE to schedule a date to come out and finalize some items before we can turn on the electricity, and there are just a few other punch list items, so the bulk of the work has been completed. Tennis court resurfacing. Work began in June and is scheduled to complete in September. Later in tonight's meeting, we'll discuss something that came up about the tennis courts. The turf care cart paths, construction is now scheduled for the week of July 22nd. We had tried to get it done in June, but the ground was too wet to complete the work as originally scheduled. Turf care building design and permitting. Design is underway, and we now expect that to be complete at the end of July. Construction is planned for winter of 2025. The 2024 road and drainage project. Work began in May and will continue through September. One of the major elements of the work this year was resurfacing Deer Run. That was completed in the 3 days that we alerted residents on that road, so that's a good thing. The first half of the culvert work is also complete, and the second half of the culverts will be completed in September. Cold Spring drainage repairs, the design is complete, and we have finally received permit from the Washington Department of Field and Wildlife. Construction is planned to be completed this summer. It's being scheduled now. Adult Center HVAC and tankless hot water heater replacement. Work is expected to be completed this summer. We'll bring it back, the revised quotation at the meeting on July 25th. The following pages of the report cover the items completed by each of the by each of the departments at SVCA. Thank you.
Thank you, Joanne.
Mr. President, can I ask a question?
You can, go ahead, Linda.
I'd like to be able to know, we've also got the clubhouse HVAC project, and I don't see any status on that at all.
The design is underway. The designer is currently looking for components that will fit into the building without demolishing some portion of it to get them in there. The unit itself is too big to get out in one piece, and so we can cut it apart since it's being replaced. Then we have to get a new unit in there. In order to avoid costly changes to the building fabric, they're spending a lot of time researching different component units that can go into it.
Okay, thank you.
Thank you for the update. Okay, we're going to move on to item number 7, committee reports. Start out with document review committee.
Oh, I knew you'd do that. We completed our work on the board policies. I'm anticipating, and I've already sent to the general manager the list of them that we have, of those that we want to have amended. We have one we want to rescind, and another one, there was nothing that needed no change. But those are set to come forward on the 8th of August.
Thank you, Linda. Moving on to finance, Lori?
There has been no finance committee meeting. The next finance committee meeting will be immediately preceding the next board meeting, which will also continue on into the joint board and finance committee meeting.
Thank you, Lori. Moving on, 7C, GM search update.
Yes, thank you. So we, at our last meeting, had revisions to the job description and profile. Those were submitted to Prothman, and their team has incorporated that and finalized the profile, which has an enclosed attachment to the job description. It looks wonderful, and it's been posted. The posting will remain open till about the middle of August, and we'll be selecting finalists and for the board to interview later this fall.
All right, thank you, Rick. Okay, long-range planning? AJ?
We did, we did not have a meeting either with the holidays, so.
Thank you. Okay, nominations and elections committee, Rob?
Yeah, so we anticipating things ramping up real quickly now that we're in July. We're going to meet twice in July, twice in August. We have, we're starting to revise the web instructions. The documents are up on the website around the AGM instructions and whatnot. So we're updating those. We are starting to look at the ballot instructions itself and seeing what we can do to get a little bit ahead on that. Next meeting, we are going to determine the dates that the candidate forums would occur. First one we should definitely have as a one via Zoom, something that people that don't live in Sun Valley can take a look and meet the candidates and whatnot. We're also talking about having a meet and greet up here, something very informal where candidates can be here, maybe have some tables set up with any literature they would like. I would just start the meet and greet with thanks everyone for being here, introduce the candidates. People can just come and say hello to them, and it'd be a place within Sudden Valley they could do that. What else? Oh, parliamentarian. Joanne learned that our previous parliamentarian we've had the last couple of years has relocated to the East Coast and would need somewhere over $2,000 to come and be our parliamentarian. So he did give us 3 names. I sent emails out. One of them came back and said, I'm not available that day. And Rich Davis kindly gave us 2 other names, so I will follow up. Also, one of the committee members suggested the previous person, there was a parliamentarian that we've used. We don't know whether she's still actively taking on clients. So I'll let you know. That's all.
Okay, thank you, Rob. Appreciate that. Okay, on to safety committee.
We haven't had a meeting since the last board meeting, so we have one next week.
Yes, we have one the 18th.
Okay, thank you very much.
Hi, Keith.
Sonia?
I guess, is there, so we just did these committee reports, at the last board meeting. Are we going to start doing committee reports at every board meeting? Because most of these committees only meet once a month. Is it?
The idea was actually just once a month to kind of get an update on, like AJ did, nothing happening and safety committee, which is fine. Or if you have an update, it's great to hear.
We'll go back to the once a month.
Yeah, did we do it twice?
Yeah, we just did it at the last board meeting.
was just getting started.
Oh, that's why. Yeah, so it's only gonna be once a month, yeah.
Okay. And then I have
Oh, I'm sorry.
just one more suggestion or request. Is it possible that the ACC can also be included on the committee reports?
Because we didn't see it on there, thank you. We're gonna amend the agenda really fast. Sorry, Daniel, and then.
Right off the cuff, ACC report.
You've seen the letters.
Just go, we haven't met.
Got a rough week, you need a break. All right, and Joanne, go ahead.
Yeah, the intent is to have the committee reports on the first meeting of each month. That's why we had back-to-backs, because we hadn't done it. And so it was on the last meeting of June and now the first meeting of July, and then it'll be the first meeting of August.
Thank you.
All right, on to continuing business, memo for status of non-voting directors.
Do you want me to read it? I don't care, but the purpose of this memo is simply to inform the board of the response made by Richard Davis, SVC's attorney, to their inquiry about the status of non-voting board members. Earlier this year, the board directed me to clarify with SVC's attorney, Richard Davis, the status of non-voting members of the board, specifically the elected chairs of the Nominations and Elections Committee and the Architectural Control Committee. It has been asserted in meetings on several occasions that non-voting members of the board of directors are not real directors and cannot be either the chair or the second director on an ad hoc committee. Is this true? So that's the question that went to the lawyer. And this is the response that came back from Richard Davis. My view of the bylaws is that the two non-voting directors are directors in all respects except for voting. Article 3A, Section 2 states that the board consists of 9 voting directors and 2 non-voting directors. The 2 non-voting directors are elected by the members, as are the other 9 directors. The only difference is that these 2 individuals are elected to their respective positions on the ACC and NNE committee. By becoming the chair of their respective committees, they become ex officio members of the board. The members of SVCA approved the bylaws which provide for these 2 individuals to be non-voting members of the board. The bylaws do not restrict their participation in any way except for voting. They can participate in all discussions, including closed sessions. They are covered by SVCA's D&O insurance. In short, it appears to me that the members of SVCA, through the bylaws, have conferred the same powers on these 2 individuals as all other directors, except for the right to vote.
Thank you for the update on that.
Can I make a comment, please?
Sonia?
Well, so in the future, I would respectfully request that my name not keep being put into the agenda in this manner. It talks about Director Volt said, I didn't request any attorney opinion on this. I defer to what the attorney said, but just a point of clarification, our bylaws refer to 9 voting directors and 2 non-voting members. Where I'm from and where I have run a business, which is not in this state, and I'll be the first person to say it, has clear definitions on the fact that you have to be a voting member to be a director. So like I said, I'll defer to the association's attorney. I want to be clear why I was making those statements, but I also didn't feel like it rose to the level of spending money on the attorney. But more importantly, I don't see that we need to name directors like that in the agenda. Thank you.
Thank you. Okay, moving on to item number 9, it's new business. At the AGM agenda measures.
I think that the reason that this sample was put in here, some directors are new directors, and it gives you an idea of what our agendas look like. It's the job of the board to generate the agenda. Generally, it's kind of the same every year. The first 8 items, I would say, are normally, they come in the same order every year. Number 9 is just new business. Measure 1 is always the budget measure. And then there's discussion of that, voting and whatever. Any bylaw measures come next. Then there's and they're printed out, but they're, then there's committee reports, the president's report, and all the different reports. Then there's property owner comments. Then we have the election results and announcements and adjournment. And then there's the thing of how to attend remotely. The only thing that I noticed difference in here, and perhaps somebody can answer me, of why there's some additional sections in here in the sample before the very end of it where it gives instructions where to it online, where our bylaws are repeated in here, and I wondered why that was added. But if it's necessary, it can be in there this year too.
Which part is it?
So we get through adjournment, and then it says all members are invited to attend the annual general meeting. Members must be present in person to participate and count toward a quorum. And then it said, in order for members who wish to speak an opportunity to do so, individual comments may be limited by the presiding officer to 2 to 3 minutes in duration. Then normally there would be how to get on YouTube, and we need the new link that goes on there. But there's a whole section in there where it quotes the bylaws and voting. And I don't know why that's there.
I think NNE requested that, if I recall correctly. Do you remember? I feel like that it was because there was some people were confused about good standing and that type of thing. I apologize. I thought it was NNE that requested.
Maybe a previous entity, but not last year.
Okay, I just wanted, because it's something that was completely unique, and it can go in there. I just wondered why, as somebody that has done it for years, I wondered why it was in there, but that's fine. But that's all I have, just for people to look at it.
Rob?
I think the other thing I should point out is in, hard to see. So, under bylaw measures, measure 1, for example, typically what we do is that measure is read, and then people are allowed to come, and the community is allowed to come and speak to whether they agree or not agree with that, right? And then we move on to the next measure. Community members come up and speak to that measure, and then we move on from there. I think what I heard was we vote. Voting's actually has been done on the ballots already and are being counted. So
it's just something new that I noticed was there, but it's just, even for me.
Yeah.
And I just thought I'd bring it up, but I just wanted everybody to kind of have a chance to see what our agendas look like. It's, eventually you're going to be voting on the whole packet and that sort of thing. And it's just kind of a heads up so you know what stuff looks like for new people.
Linda, would you prefer that those, the bylaw sections, do you think it's extraneous? It doesn't need to be there, or what? Are you suggesting that we remove it, or?
I think if there's room, I know hopefully we'll see, there's 2 bylaw measures being suggested tonight to go on there.
Okay.
If they're there, it all depends upon how much room they're going to take up in description and stuff. I don't think that much.
Thank you.
AJ first.
I was just gonna say, in regard to, like, you were talking about members coming up to speak, like at the AGM, our last parliamentarian recommended, after the last AGM, that we potentially consider providing that time to speak for the community members at a town hall event, because at the AGM, we typically see about 1 ballot from the floor. So at that point, everyone's already voted and it's kind of pointless. And so it's like, you can't change your vote. Even if you change someone's mind, it's too late anyway. So maybe something to consider. And then I would just say we should provide an exact amount of minutes that we'll provide to people to speak. 2 to 3 minutes means the chair has the flexibility to cut people off as he sees fit. within that time frame. And I think that's unfair. We should just provide a set 3 minutes like we normally do. And I don't see why we would need the bylaw references directly on the agenda, but it's not like it's harming anything either.
Over here and then we'll go over there.
I just have a quick question for AJ, because I also thought I remembered that the parliamentarian said something about we have under each measure, and it doesn't show because it's only under measure 1 right now, about discussion,
Yeah, that's what I was just saying.
that we can eliminate that and just go from the presentation of the budget to voting.
He, I mean, I'm going off of memory, but my recollection of what he told us was discussion at that point is basically it's not even germane to the conversation anymore because the 99.99% of the people have already cast their ballots. They can't change it. So that's why he suggested like a town hall type thing before the AGM, you know, so it'd have to be timed in advance at some point so that it gives people the time to still change if they want to watch and hear people and change their minds about different stances they may have or whatever. Still gives them time to change their actual ballot accordingly.
Rick?
No one usually talks ever.
Well,
either.
I was just going to say something a little different than that, which is we also have to fill up time because Unilect is coming up with, the numbers and everything. So that's part of, like we do that one general discussion where people can bring up any topic, but then we allow them an opportunity to come in and just make comments on whatever those bylaws are. And I agree with AJ, we really need to encourage people to participate in the town halls and speak during that time if they have opinions. But I personally think it's kind of nice to just list the discussion after each of the bylaws. It does give people an opportunity to be heard, and like I said, it fills up time.
Thank you, Sonia. Rick?
Yeah, so being relatively new, I'm not familiar with the timing of the town halls and the candidate discussion or candidate forum. Are those 2 separate times? And how far ahead are they ahead of the AGM?
The town hall is scheduled for mid-August, correct?
Okay.
And Rob would have to address when they plan on doing the forums. It's usually sometime after the candidates are received, which is the first week of September. And then after that, once they know who's running for what positions and that sort of thing, then they can schedule the forums.
Yes, and the other consideration is that there are members who live outside of Sudden Valley where it would be good for them to have a ballot in hand, and then the forum would occur at the same time they have a ballot in hand so they can vote.
Yeah, I agree with AJ. I think, having a bylaw discussion prior to the AGM makes a lot more sense. And I don't know the timings, maybe I could, depending on how many candidates, I guess there are at the candidate forum, I could foresee a discussion of the bylaws and then the free forum flow with the candidates so that people could ask the candidates how they feel about the bylaw amendments. I mean, just a thought.
Thank you, Rick. AJ?
So we have the town hall is going to be before anyone gets their ballots? So they won't have the information before the town hall?
It's 8/17 is on here.
And don't we approve the ballots like early September,
I think
end
that
of August?
got bumped up to allow for the very thing that you're requesting, though. I think
Will we want them to have their agendas and their ballot packet before we have the town hall? Otherwise, we're going to have to push all that information, I guess, just through our website, which only reaches the people who pay attention.
Thank you. Joanne?
Um, the timing of the town hall was also influenced by wanting to hold the town hall and get feedback from the community about the budget before the board held its vote on the budget. So there's no reason we couldn't have two, but the idea was that um, the budget would be presented and there could be questions about it, and then there could be time for that feedback and other input to the directors before they vote.
Thank you. Any additional comments?
Yeah, we need to, are we deciding something or we're just reviewing that? I don't know what.
It's just, we have, Stu is new, although he's on by phone and stuff, but it's like, these are people that haven't been really part of a process, and it's just to help you understand things a little bit and how they'll come together. It's all stuff that eventually, when we decide if there's going to be bylaw, if there's going to be any bylaw amendments, if there's, when the budget is finalized, the numbers will go in there. And eventually that becomes part of the packet that's sent to the membership, and that's voted on by everybody to do that. So, and the agenda is part of it, and it's just something that's the board's responsibility.
Thank you, Linda.
Okay, so, sorry.
Go ahead, Sonia.
Well, I'm just, are we still going to hit each of these topics? I mean, like, are we going to go 9B and discuss the bylaw measure, or we're just kind of, I guess I wasn't quite sure what we were doing.
Yeah, I think we should. We'll start the conversation.
Okay.
Yeah. We had some good points tonight brought up, so we need to get the town halls prior, some good stuff, so we need to work on that. Moving on to 9B then, proposed bylaw amendment, leasing. Linda?
Well, let me do this. These are my babies. So after listening to the first conversation, when we actually had the discussion, there's nothing in our bylaws that allow us to do any regulation whatsoever of STRs. Our bylaws only currently include long-term rentals and leasing. What we'd like to do is we have currently not a lot of people who rent their properties long-term file the lease with us as they're supposed to. STRs, there's no way for them to even do that. So after listening to people and not wanting to put a ton of stuff on the association, we came up with this current bylaw amendment that explained, I'll do so the ballot will say, shall Article 6, Section 7, leasing be amended to provide for fines for owners who fail to comply with required governmental regulations and SVCA bylaws pertaining to the leasing or rental of their property in Sudden Valley. Explanation. The current bylaw language lacks penalties for members or owners who lease their properties without notifying the association. Although many properties are being leased, compliance with the bylaws in providing necessary information to the association is not occurring. This information is critical for the association to respond to complaints and to monitor usage of facilities. Short-term rentals provide an even greater opportunity for owners to rent their property without notifying the association. In addition, there are county and state regulations regarding short-term rentals that owners must comply with to lease or rent their properties. This amendment is intended to enhance members' compliance with the bylaws and applicable laws. Then the section on leasing says a member or owner may lease or otherwise transfer use of occupancy of any lot for residential purposes only. The term tenant as used herein is defined as a person to whom a member has extended use of his or her lot as evidenced by a written lease or rental agreement. the lease or rental agreement and name of property manager, if different from the owners, shall be filed with the association prior to the commencement of each rental period. Failure to provide to the association, failure to provide the association with a copy of each lease or rental agreement or the name of the property manager will result in a fine to the owner of the property. Neither the lease nor the rental agreement shall relieve or release owners from obligations and responsibilities incidental to their membership, including the personal obligations to pay annual dues and assessments, special assessments, fines, or charges associated therewith. If an owner rents to another member in good standing, then the owner need not assign his membership rights or privileges. The next paragraph is just strictly out of what's existing. Only one couple with their dependents or not more than 3 unrelated adults are permitted by any one single-family dwelling unit and are considered tenants for the amenity use purposes. A member in good standing, this remains unchanged also, who leases his or her residential unit may assign membership privileges to the tenant, provided, however, that the tenant shall have no right to vote or right to notice of any regular or special meeting of the association. Privileges shall be reinstated automatically upon expiration of the lease. The next section gets a little funny. It's where we get into short-term rentals. Any member or owner leasing property for less than 30 days shall be, but it's out. Rich has looked at this.
Is,
Considered short-term, shall be considered a short-term rental under Washington law and shall be required to meet all county and state regulations applicable to STRs for such activity. Failure to meet all short-term rental regulations shall result in a fine against the property owner. Currently, STRs are a required conditional use in the Lake Whatcom watershed pursuant to WCC 2051-075. All owners providing such lodging shall possess a valid conditional use permit. Owners of a short-term rental shall be required to supply information to the association with the address of the property and any contact information for said property. Failure to do so will result in a fine for the owner of the property. A member in good standing who leases or rents his or her residential unit may not assign membership privileges to the transient tenants renting on a short-term basis, as assigning membership privileges requires the names of the tenants assigned to the privilege. The next paragraph is unchanged. The final paragraph that's part of that particular bylaw, I've erased. We haven't done, I don't even know when we've ever done that, and if it actually opens us up to risk to do it. It reads, if the association agrees, the lessor may delegate and assign to the association the authority to evict the tenant on behalf of and for the benefit of the owner. In the event the association proceeds to evict the tenant, any costs, including attorney fees and court costs associated with the eviction, shall be specifically assessed against the owner and shall be a personal obligation of the owner. Once membership rights are assigned by an owner, the owner shall not have privileges to use the amenities or facilities unless otherwise provided by resolution. We've never done any of that, and it's been on the books for forever. And quite frankly, I think it's kind of a risky undertaking for us to evict someone. We've often said that's one of the things is you don't, if they have a tenant in there, it's something between, it's a personal thing between an owner and their tenant, and the association really doesn't have any really business being involved. So that's what that all reads. Rich didn't understand something, and there's a note here goes, this doesn't make sense to me. When an owner has a tenant leasing their property, there is a form they can fill out with the name and information of the tenant and giving them their use rights. If you have someone in a short-term rental, you're not going to have them long enough here for the owner to sign an agreement, to have that, to have those things used. It has come to my attention that recently a manager of evidently at least a couple units out here that are short-term rentals came into the office and wanted to get a use card that would just be at that residence and anybody can use it. That isn't how we do it. So they would have to come in and use, they still could use the golf course, the pools, whatever they want, the main pool at least, and just have non-resident fees that they would pay. So that's where that goes. I know Rich didn't understand it, but
I had a quick question on the, would STRs, on the part where it says only one couple with, excuse me, question on the STRs where it says only one couple with their dependents, would that also include STRs? Not more than 3 unrelated adults and so forth?
that's what's scary is there's no way right now currently to control that. So does that need to come out of there? I don't know.
Oh, I think. Go ahead, Joanne.
Our attorney has previously commented on that provision by saying that there's no ability to enforce that. And it's one of the items that has been noted by members making comments that there's actual case law showing that can't be maintained by an association. So we can put all sorts of things in our bylaws. I mean, no one's going to police that, but if someone challenges it in court, it may or may not stand. And Richard has indicated that limiting occupancy in such a way is unlikely to be supported by the courts as it has not in the past.
Thank you. Okay, any additional? Yep, Sonia?
Yeah, to Joanne's point, is there a reason that we would need, it feels to me like we don't have enough information about this. We know that the county is still discussing this. This has been going on for a while. We see that there's a lot of member input regarding this. Is there a reason that you feel that this needs to be a bylaw change and not something that we could potentially address initially through policy while we gather more information, allow more community input? And I'm also a little worried, like what Joanne says, we can put a lot of things in our bylaws. We're going to clutter it up. And what happens if the law changes next year? They're in discussion, which they have been. And again, I just feel like we haven't had enough input from the members. But I'm just wondering, what is it that we're trying to get to by adding it into the bylaws as opposed to lining them through policy?
After looking at the policies as much as I have, I would far rather have a bylaw amendment than a policy. Our policies, I can't begin to tell you, and you're going to be able to see on the 8th how we change things. We don't update our policies. It's like they go away to a land far, far away. And it's like with the bylaws, it's something we always look at. The reason I'd like to add STRs is otherwise we wait another year. We already have, according to Airbnb, 100 people in here that are renting theirs. That doesn't count Verbo. And it's like, I think it, without saying we're going to go track down everybody, we're simply asking them, follow any state or county laws. I'll be happy to oblige as an association to anything the county puts out there. The county has already amended it to say that short-term rentals and vacation rentals are a conditional use in the watershed. How many of these people have conditional use permits? I don't know.
None. Because it's not a thing yet. Planning department hasn't put.
It's on the books.
Yeah, it's on the books, but the planning department hasn't actually executed a plan to manage it yet. Even in the ordinance, when you read the council's agenda on that, it talks about how the planning department's going to need time to get software and the proper pieces in place to manage the new code.
That's for them to manage it. And basically, it says that this addition that's made that they're conditional use. Number 6, the county council held an advisory public hearing on May 10th and a duly public noticed hearing proposed July 25th. And it then says that amendments to the Whatcom County Code related to defining vacation rentals and specifying the zones in which vacation rentals are allowed and by what permit is shown as Exhibit A are hereby adopted and shall become effective 10 days after the county executive signs the ordinance. So it's law.
Yeah. I was
Further,
gonna say, what-
planning and development is supposed to find a way to engage a vendor to develop and administer a vacation rental registration system.
Yeah.
They haven't done that, but that still, it doesn't mean that it's not now a conditional use. That went into effect 10 days after they signed it.
Yeah, but I'm not sure they're even accepting conditional use applications yet or not.
I have
without
no
that
clue.
software.
I'm just saying, if it's a law and it's something they have to have, and when the county gets ready to do it, I'm ready to do that. There's state laws that says that some of these, if you, Department of Revenue says these people that have these STRs, if they are on Verbo or Airbnb or one of those, they're considered a business. They're not even considered a residence any longer. And they're considered what transient lodging. It's not even that they're considered tenants like we consider tenants in our bylaws. So you have all that stuff that's there. That will the county come around to that? They probably will. The city of Bellingham has already outlawed STRs in the watershed, plain and simple. They have the vendor that they're using. The one gentleman that came in here gave us a bunch of documents that I all sent to you, and there's a company called Granicus or something like that. They're the company that does that, and you can pay them so much to manage your stuff. And they basically tell you, no, this person's here, this person, you know, you have to have a business permit. There's all sorts of stuff that's supposed to be done right now is being just, we don't know. Other than there's been, you know, I've been reading my board mail and there's lots more now about houses. There's one particular one in here. Oh, Stu wants to make a comment when I get done. But it's like, I think it's a beginning step for us because I'm certainly not going to, I would like to have them register so we know they're here. That's the whole point of having a lease on file with people that do long-term leasing. So that's kind of what I got to say.
Lori? I know, Stu's next. Lori had her hand up.
Okay, well, I propose that we add one additional thing in here that we state, and shall be required to meet all county, state, and federal regulations applicable to STRs for such activity. And then failure to meet all. I think because this is a bylaw, we should reference currently, because that means that if that changes, we have to change our bylaw. I do think it should be a bylaw versus a policy because this protects those that are short-term rentals. And it also protects those who live near short-term rentals. So this is actually this will benefit those owners who do rent their house out. So if we could take out where it says currently vacation rentals are required to conditional use permit, because if that's the case that they do, that's already covered in this county and state regulations. So we don't need to repeat it. That would make that 3 lines shorter. And I think the main reason that we do need this is so that we don't have to rush to change something should a state, county, or federal law come into effect that will change how we have to look at short-term rentals. Also, it requires them to, the owners, to give us their contact information. If we have them, you know, they might live locally or even here in the valley and they're checking their mail. We might not even know they don't live here and not have a good contact information for them. So this will, even if it's a property manager who's doing it, or if they're self-managing, if they're local, it gives us basically their agreement with the property manager or VRBO or whatever would be a substitute for a lease in the case of a long-term rental.
Thank you, Lori. Stu?
Yeah, actually, it's just kind of an interesting thought or comment because Linda said the VRBOs and Airbnbs are not considered short-term rentals. They're considered businesses. And don't our bylaws state something about having businesses run from your home? But what if your business is your home? You know, I seem to recall that in there somewhere, and maybe Sonia or AJ are more familiar with that. But you know, I think this needs a little more research, actually.
No, you're correct.
And that was my only comment. It seems like there needs to be a little more due diligence with respect to this and how things are actually going to be classified.
Thank you, Stu. Any addition? Go ahead, Lori. One more.
I might have been dreaming this, but I thought I was discussing with someone or conversing with someone that for the short-term rental or like a VRBO or Airbnb, in order for it to be classified as a business, the owner of the property had to provide a service such as, you know, breakfast, like in a bed and breakfast or daily housekeeping or something like that versus just giving exclusive use to their house was not considered a business but considered a rental. Don't know where I remember discussing.
From me.
Thank you.
Yeah, that's correct.
From the Department of Revenue of the State of Washington, it's called personal home rentals. Short-term basis less than 30 days in a row is considered a personal home rentals. It says, the department will assume a property owner is engaged in a taxable business activity when they do any of the following: advertise the property available for overnight accommodations through online marketplaces, newspapers, or other publications. Doesn't say anything about serving them food. I have got stuff till it comes out your ears. There's
AJ?
another section of the Washington DOR that's called lodging, transient short term. And it says personal home and room rentals less than 30 days in a row. And it apply, you know, this types of lodging include bed and breakfast, hotel, motel rooms, personal home and room rentals of less than 30 days in a row, recreational vehicle parks, resorts, rooming and boarding houses, summer camps, condominiums and timeshares, cabins, and camping sites.
AJ?
I got kind of several things. I personally think we should get an official attorney opinion memo from Richard on potentially this topic and what we are actually allowed to do. And if those are considered businesses now, that potentially changes the entire conversation. And I think I agree, more research or all of that documentation needs to be provided to the full board so we can evaluate that type of stuff. Couple of things. The whole not more than 3 unrelated adults, if that truly is unenforceable, it should be stricken. I think even if it's not, it should be stricken because I don't see that it's fair that someone who owns a 4 or 5 bedroom house can't rent their house out at fair market value because of that, or they're going to have to do it and people are going to have to pay more because they can only have 3 people in a 5 bedroom house, even if it's a long-term rental. I agree. I don't think we should include the language directly referring to the Whatcom County Code. I also don't think we need to have the owners provide us their conditional use permits. That's the county's jurisdiction. They'll be handling that stuff. I think I have a question on this because there's like up in the top under leasing, is that only, the first paragraph, is that only related to then long-term rentals? And then the
Yes.
one paragraph is only related to short-term rentals?
That's correct.
So with short-term rentals, then they're not required to supply the contact information for every single guest that rents their house. They're just responsible for providing either their property manager, or if they're doing it personally, then they're themselves as the owner. Is that accurate?
It would be nice. I don't know how you would even make someone send you each individual contract. It's so different than a long-term lease.
Well, do they even have contracts? Is the owner have a contract with VRBO and Airbnb, or do they have a contract with these individuals? I don't know how that works.
Most of them have contracts with Verbo or Airbnb. You sign up. When you sign up, I do Verbo a lot. When you sign up, they will tell you if your dates are available, then they will put you in contact with the owner or the owner's representative. At that point in time, they will give you a contract, and that contract is binding on you. It tells you how much you pay per day, that sort of thing. Most times in Maui, I also get a secondary document that tells me what the rules of the particular unit are.
Yeah, I understand.
So it's
that.
handled through,
I guess I'd like to see that research
we have
provided to
we
us.
have an attorney's opinion.
That's like
There's
accurate. That the contract is with, because if they have just a contract with Airbnb or VRBO, if it's not a new contract each time, and it's just like this standing contract with that online marketplace that then helps facilitate the rental of their property or whatever, they would only have to supply that once. But if they have to sit and send, every 2 days they're sending over new contracts, like, do you even want that?
Well, I was going to say earlier that your mention of how the county is delaying until there's a process to figure out who are the short-term rentals and how to manage this. That's the same reason that I haven't brought back the preliminary opinion of our lawyer on some of these things, because I don't. First of all, there are questions about some of them that are supported by some of the research that Linda has done. And second of all, we would have to create an entirely different infrastructure to be able to manage it. The first step would be simply understanding what properties are being rented, either long-term or short-term, and getting the initial contracts in place. And we do have a mechanism for tracking that in our system, but we don't have any mechanism for tracking. Like we can put into our system, this is a short-term rental and it's marketed through Airbnb or Verbo or some platform to be named later, right? We could do that, but we don't have a mechanism to say, this is an Airbnb property and Thursday night it's, Bob is renting it and Saturday Joe is renting. Like, there is no way we can track that.
Yeah.
So to even ask for the contact information in those cases is foolhardy. And yet our current bylaws say that if you rent your property, you got to send a contract to administration. So technically, if we established a fine for failing to follow through with that requirement that's legal and supported by law, case law, we would have no way of figuring it out. You see what I mean?
Yeah, exactly. And kind of what I was thinking, and just, because I guess I wasn't clear that the top paragraph is strictly related to long-term rentals. I think we should say that. I don't know that that is actually said anywhere, that's clear. The way I read this, that upper paragraph applies to all of it. So, but then the short-term rentals have slightly different requirements. It just says required to supply information to the association with the address of the property and any contact information. And it seems like the information we really want is if the owner's managing it themselves, we want their contact information if they have a property management, because those people have, it's in their best interest to resolve any issues we're experiencing out here with their tenants. And just like they said over here, these people who talked about having short-term rentals, you know, like we already have mechanisms in place for garbage and those things. The security should be able to handle those. So that's not anything necessarily new. You know, I just wanted to clarify, I guess I would say we should somehow clarify long-term rentals have different requirements for providing lease and contact information, because I'm assuming for long-term rentals, we actually want the tenants' information as well, since they're living here on a more permanent basis. And so some clarification there. And then, yeah, I just wouldn't want to like create an undue burden on staff or an undue burden on these short-term rentals where they have to be constantly sending us information.
That's why if they register, we just know they're here. We know where they are, who they are. Actually, Airbnb and Verbo, I know for sure, because I didn't look at all the others. When you use one of these marketplaces, they have to be approved by the state of Washington, because Airbnb at least pays taxes, does all sorts of things like that for these people that register with them. And so a lot of this is taken on. And there's actually, when you start drilling down into the DOR, they tell you, if you use one of these marketplaces, here, look, this is some of the rules you have to follow. And it's just all there. And if I just say state, federal, and county laws, I'm happy with that. You know, it's
Yeah.
like,
I think
to me,
that's,
the city of Bellingham has already banned STRs in the watershed where they touch the watershed.
So
You know,
a primary consideration is if we know where the short-term rentals are, then we can walk the property with the owner or without the owner, just notifying them of our intention to do so, and figure out how many cars can be accommodated. That's something that can then go into their listing. Or they can, and then we can suggest alternate places and means of parking that are safe for each location. That's just one example of a way that we could better manage a short-term rental within a neighborhood. The complaints that have been surfaced about the short-term rentals are just what was said earlier today: noise, parking, and garbage. One of the hidden costs of short-term rentals is that many short-term renters come into the Welcome Center. We had one just earlier this week to say, "Hey, I'm here for the weekend. Can you explain everything about your association to me? How do I get in the pool? Where can I drive? What are the best trails?" And while we're happy to help people, we're not the concierge of their Airbnb. Where's a good place to get dinner? How come there's only one restaurant? Oh, there's two restaurants? You know, how long will it take me to drive here? How's the best way to get on the highway? And like I said, a little of that goes a long way when we're already a little pressed for time. So another consideration.
yeah, okay. And like, last thing I wanted to bring up was by eliminating the language that requires them to supply us conditional use permits, there's also mechanisms for people who have been running Airbnbs before that ordinance was passed to get non-conforming use permits, which is technically not a conditional use permit. It's something different. So we would need to address that if we continue to like reference specifics. So I think, yeah. And then the last point I'll make is I just want to kind of summarize where I stand on this. You know, I think there's an importance to knowing where short-term rentals are and being able to manage that accordingly. I also don't support trampling on people's property rights in any sort of excessive way. So I think, I think we need more research on some of this stuff and a little more information provided, a few clarifications, and stuff. But I think generally it's, It's not, I don't think the burden of providing the property owner or the property manager to the association is too extreme for a short-term rental. That seems pretty reasonable. We'd require that of a long-term rental too, so. Yeah, but I would like to hear something more about the whole concept of the business thing, because that
DOR.
changes some things.
Rich could look into that because like I'm saying, the DOR, when you look, it's like they have, most of the times they say, you're a business, you need a business license. You know, there's stuff like that that we don't know. Hopefully all these people are doing it. If they're with someone like Airbnb or Verbo, they will be required because they won't take them on as clients, I don't think.
Wait, we got
No.
Sonia, Lori, and then.
I was just gonna say, because we do have.
Go ahead.
She hasn't talked yet.
Yeah. Sorry. Just because we do have one, Verbo and Airbnb do not require you to have a business license. They don't care. But in White Rock, I mean, it's Canada, but it's going to be the same. The city says, I have to have a business license. So I can't imagine that it's different down here.
Sonia and then Lori.
Yeah, so all I was going to say, so obviously we're going to be bringing in some more documentation and research, which is awesome. And if it's determined that we either can't, if we can do short-term rentals and if we want to move forward with short-term rentals, I'd also like us to be considering a permitting process, along with that. They need to fill that documentation out. They need to pay administrative fee for us to handle all of that. So they're going to register with the office. And that's when Joanne can, or whoever, can give the instructions of, whether we're going to limit the parking just generally, or if it's, we're going to walk your lot, whatever, same thing as how we do with ACC stuff. I feel like we definitely should put an administrative charge in there, and it's a permit. It's all spelled out.
I think if the county goes that way, then you'd have that permission to be able to charge a fee and everything else. If you looked at some of the fees that the city of Bellingham charges STRs, you'd be shocked, is all I can say.
Well, they do cost us more money. Lori?
Just really quickly, I agree that we should take out the only one couple, the thing. In regards to just looking quickly over what Linda has, being registered with the Department of Revenue, having a UBI number, that would all be included in federal, state, and county regulations. So that's going to cover a lot of it. And like, for example, let's use the RV storage. We require them to turn in specific documents, right? Like the
Registration
and
and
things like that.
insurance, yeah.
So if you think of like short-term rentals as like just renting a spot in Sudden Valley, us requiring the owners to just turn in that document, like maybe a copy of their homeowner's insurance policy, in case it says this does not cover rentals. We want to make sure of that. And also having a copy of their business license, just basically things that just be provided once a year or whenever it needs to be renewed. And then just charge a small administrative fee, I don't know, $150, $500, something like that. And maybe then a renewal fee or whatever, but that's something we need to work out, and that would be part of our fines and fee schedule, not part of our bylaws. And then because of that, we should take out, we mentioned fine against the property owner a couple of times. It should probably just be mentioned once at the conclusion that, not adhering to the above will result in fines to the property owner. And then I'm talking too much. To touch on Sonia, when they do register, we could put together just like a one-page sheet flyer saying, our pools are located here, the price is this much, blah, 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 that we can give to the owner, and it would be their responsibility to include it in their ad or to laminate it and stick it on the refrigerator or something like that. And that would be part of what they would receive for paying that yearly fee. And I do think this is really just listening to the property owners' comments here today, is I don't think they realize how much this actually protects them. It's not meant to hurt them. It's meant to protect them and to protect the community as well.
Thank you, Lori. Any additional comments on that? All right, hearing none, we're gonna move on to,
Can I ask just a question? So
Nope,
what's
too
what-
late.
What specific actions are we taking? We got a
it's
lot of
just
good.
right now, we're just reviewing everything, getting comments and feedback, which we hopefully did a lot online, but apparently not enough. So this is good. And we're not doing any voting on these tonight. We're just gonna kind of get it directed and brought back more clarity. All right, next, we're gonna move on to 9C, proposed bylaw amendment for terms of office. Linda?
Oh, so this happened when I was looking at some stuff. We have two articles that kind of contradict each other. And the one that I'd like to have changed simply by it's our process, and why the bylaws say something different is beyond me. And it's where we say a director shall be elected and hold office as follows. And it goes on with item A. And then there's 3, directors shall be elected each year except when additional directors are necessary to fill vacancies otherwise existing on the board. The term of office for each director shall be 3 years or until their respective successors have been elected by the association. However, a director who has been appointed to fill a vacancy shall serve until the conclusion of the following annual general meeting. That's the part I want changed because it says, and until a successor is elected. No, if we've had fewer candidates than we have openings, we elect those people. Sonia, Timey, and Sam were on 1 year when we had 4 openings, and we simply had a vacancy. And at the first meeting of the board, when the new board, then a vacancy notice was put out and applications were open for 30 days. And we basically then went through the process of interviewing people and appointing a candidate, but they only serve until the AGM, not until their successor is elected. That's the only thing I want to change, because otherwise, if you had only 2 and 3 people and 4 openings every year, you could have an appointed person staying on forever and ever and ever and ever. And that's just, it's not what we do.
Thank you, Linda. Sonia?
Yeah, so there was a comment earlier, and I think it may be because of the attorney's comment over on the side. If I'm understanding you, so I just want to clarify to make sure, you're saying if someone is elected, but for whatever reason they leave before their term is up, then whoever the board appoints will only serve until the next AGM. This does not change that. It's just that the attorney made a comment on the side, and I think, that's correct, right?
But that's exactly it. That's
Okay.
what we do. I don't know why it's in.
Yeah, we're not discussing
Yeah.
extending it for any period of time.
No.
Okay.
No, he's just pointing out that it would be legal to do so, not that we are.
And by the language in here, our bylaws would limit us from being able to do that, correct? Okay. Clear.
Hey, Rob over there, how are you?
No, I was just going to point out, I agree with what Sonia's comment. I was a little surprised when I read that. I thought, wait a minute, no. We want to ensure that things are clear that if someone is filling an open position like that, or someone needed to resign, that is just for that term until 1 year or less until the next AGM. That's been our practice. It works well. And I was a little like, what? Wait a minute. What was that when there was a comment earlier too? So
Well, when we're done, I just, that was a totally different thing to talk about.
Sonia.
Sorry about
And
that.
then I'll go to
And
AJ.
well, because one of the things, so, the, Wakiowa, the HOA Act has basically been rescinded and almost all of those portions have taken effect. And it also reads in there that all committee members are to be appointed by the board. So I believe from the way I read that, that has already taken effect. And if that's the case, that would mean that we're not electing NNE or ACC anymore because it's overridden by that RCW. It says it took effect June, got the date, I can pull it up real quick, but all of the portions, it was only one section that had to do with foreclosures and stuff that did not, there were a couple of sections, financial type sections that didn't take effect immediately, but it appears from my reading, and I may be wrong, but that it appears that that's in effect now. And I think we need to confirm whether or
The
not it
attorney
is.
should tell us that then, because I understood that all of Wakiowa will become law on January 1st, 2020.
I have noted the specific question, so I will follow up with her.
So here's what it actually says. So RCW, Senate Bill 5796 basically rescinds all of everything that we're normally governed under the HOA Act, et cetera. And then it says it impacts common interest communities, effective date June 6, 2024, except for certain sections that it names. That part about appointing committee members is not in the sections that are excluded to then become, it names off section 319, which takes effect January 1st, 2025, and sections 401 through 432, which take effect January 1st, 2028. So we are being governed under this right now, almost all of this.
We should ask Richard then, because there's been no information from the attorney to say that that's the case.
And I know this is off topic, but it brings me to that point of speeding, because one of the things that's in here is actually says that the local law enforcement has to patrol the streets as long as they have an agreement with the HOA. So that's good.
We've noted that.
Yeah.
Try and tell the sheriff that.
AJ?
Yeah, I would agree. If that's true, we should learn the details on that. I support the way the language is. I don't support Richard's suggestion to allow vacancy filled positions to remain longer than the AGM, next AGM. So I think, yeah, the way it's written with the strikeouts and stuff is acceptable, but I would push back on Richard's suggestion, just as I don't think that's really how we've operated. And I think it does create that situation where someone could just kind of sit there perpetually in this random weirdness that they basically would have to like resign from potentially.
So strange. It's like sometimes you can read these bylaws so many times and you can think you know them word by word. When I first got elected to NNE, I thought that I could resign after 2 years. And another member pointed out, no, Linda, see, it says you serve until your successor is elected. And that's why I ended up on NNE for so many years, because nobody ran for NNE.
All right. Okay, we're going to move on. You have enough comments?
I can bring back a clean copy next meeting. How does that sound? And I can do the other thing with bringing back more information and send it to the board beforehand and see if we can get things taken care of.
All right, we're going to move on next to request for approval for the NNE manual revisions.
Just to clarify, we don't want a clean copy, right? Because we put the red lined copy in the agenda or in the ballot, don't we? Because the membership needs to be.
But I want you to be able to read even when I look at Richard's edits, I'm going, I can't read this because of the blue and the.
Oh, yeah, okay.
You know what I
Okay.
mean? I could redline it. It's just to clarify some of the things, the changings we've made.
But when we put them out to the membership, right, it includes the red line, so they see
No,
that.
not red line, but
Or
because we're
bolded,
black and
dark,
white,
yeah.
we do the bolded and we do the underline or the strike through.
But it's, yeah, track changes are used.
Absolutely.
All right, yeah, okay, thank you.
All right, moving on to 9D, request for approval for N&E manual revisions. Rob?
All right. So the purpose of the approval for the revision of the N&E manual is just that we're requesting some revisions. Most of them are, and you'll see, are really just minor edits. And so the background is the N&E manual has been revised in the last few years as an Adobe PDF document. These revisions affecting the formatting of the original Microsoft Word document, making it awkward to read. Beyond improving the formatting, a few clarifications and additions are proposed. And there is a menu here. I don't know if I need to read verbatim, but you can see things like the title page. That's pretty self-explanatory. Some minor formatting and grammar changes. A legal opinion is added. A lot of this is when you see minor formatting and grammar changes, they are editor best practices. So trying to bring the document that had been revised under a couple of different softwares back into Microsoft Word, that's something that we can put into our repository and hold it. And then going forward, if any changes are made to the document, we will do so under Word and no other documents. So I don't know if you guys have questions, rather than going through this thing, getting kind of late, but going page by page by page, do you guys have any questions, concerns?
No questions, anyone? Go ahead, Sonia.
Well, it's not really a question, but I did just want to make a statement. I agree with removing the communications committee because that's an ad hoc committee, et cetera. But I do think that we need to offer some kind of assurance that, this has been the ongoing thing. So I've already gotten a couple of emails where people have expressed some concern, where it's worked out pretty well the last couple of years when it's a relationship between the general manager and the N&E committee, where it's not just totally the N&E committee, where, there's some assurance that the programs kind of run unbiasedly. I don't know if there's some language that maybe could just be added in there. I'm not really sure. I'm just throwing that out there that.
What language are you prefer?
I don't know.
Well, I'm looking for a suggestion. What are you suggesting? Because every year somebody's going to say, I don't trust you. I mean,
Yeah, and that's my concern. And that's why I was trying to do we did the kind of checks and balances, like this hand and this hand. And so and that seems to have quieted a lot of that pushback. So I'm just wondering if it's, some way to do that again, like, okay, it's the N&E committee, right? It's hosted by the N&E committee, but potentially MC or just overseen by the I don't know, the general manager. I'm just trying to find a way to.
I personally would be opposed to overseen by the general manager. The N&E committee, our role is to.
Well, how about if you just, I'm sorry, I'm trying to find the section where it says that, because it might actually even address what I'm talking about. Do you know where it is, where that was removed?
Let's see. So in the menu, it is page 21.
Because it may just be something where, the N&E committee is committed to hosting an unbiased forum or something like that. You know what I'm saying? Like a statement from the committee even.
Now, one of the things that we've talked about in our committee is the possibility of having an MC, if you will, at the candidate forum that would be somebody who's not on the committee.
Yeah, that's exactly what I just suggested to but yeah, exactly that, where it just, that eliminates that. It's someone that's kind of out of any sphere, pretty much, where he's going to get accused of a bias, right?
That's why. Isn't that why we hire that third party group to come in and counter the ballots? That they're non-biased? We pay them money. We got a contract on it. You want to get this thing approved so you can go to print with us?
Yes.
Okay, Joanne?
It's section 4.2. It's called candidate forums. 4.2.1 says the candidates forum is a showcase for the candidates. 4.2.2 says the forum will be scheduled, managed, and moderated by the Nominations and Elections Committee. You could add 4.2.3. The Nominations and Elections Committee is committed to providing an unbiased forum.
Yeah. I mean, I just think it's just a way to, I mean, there's no guarantee of it, but it's just an assurance, right? That there's not biased questions or.
It'd be also the same problem with having like somebody not associated with the committee, who's going to pick that person? Because
Yeah.
then someone's going to say that was wrong.
Okay.
So I would ask the question, when the board asks interview questions to a potential people filling a seat, where do those questions, are those done by an unbiased? I mean, I'm not saying that they have.
Oh, I actually hear what you're saying, and that's the thing too. Maybe it's that we allow questions from community members. Maybe it's just that type of thing, Yeah, I don't really know. You're right, that because everybody comes from their own perspective, and they're, and like with the board, we've talked about that. We're asking people to, like, where you stand on this, how are we going to work with you? We were trying to get to know this person. So so it's fair enough. I don't know. I just felt like I needed to say it because it's been commented to me, but I actually don't know the solution.
I'm hearing you, and I appreciate your feedback. Seriously, we got to be upfront in these forums for sure.
Linda?
I just wanted to point out in the bylaws, there's a section that says that when it discusses the board and everything and who's eligible for election, it says all eligible candidates shall have an equal opportunity to communicate their qualifications to members and to solicit votes. I think that's the one thing we've always done is began any question and answer period with each person having the opportunity to express their qualifications and say if they want, for me. But there's that part of it that I think is really important, that each candidate is allowed that opening statement. Questions after that. I like the idea. We used to go around and solicit questions on pieces of paper when we did it in person. And then you just picked from just totally random, somebody picks from a hat.
So what about including what she just read? Like it's part of the bylaws, but just making it part of that section, right?
But every forum starts with that. Each forum starts with the candidate has the opportunity to share their qualifications and their right rationale why you should vote for them.
Right, but I don't see it. It's not actually written in here, right? In the manual. I'm just saying maybe that might actually address, it's just right there. We kind of repeat stuff sometimes just to make sure that,
Do that?
that might work. What do you think?
I understand as long as that's guaranteed. I'm not sure if it's in here anywhere else. I know there's sections in here that say what parts of, and I'm not gonna be able to find it right now off the top of my head, what parts of the bylaws have to be, that the committee is required to provide and govern by. Governing the entity committee, the purpose, meetings, voting, meeting. I'm looking just on the red line here. I'm sorry, folks. Section 3, nominations of directors, A, B, C, D, and F. That's all it says. It doesn't, you're absolutely, it refers to it, but it doesn't spell it out that I can see. And it might because I'm looking at the red line version.
AJ?
I'll be honest, I did not have the time to review the revisions to the manual, but just kind of a point based on the conversation and stuff. I guess I'd be curious to know if maybe there is some sort of vendor or consultant that's not super expensive or something maybe that could be like an MC. I don't know that it's really appropriate for the committee to then just pick a random community member to be that person. That's gonna create a situation that could reek of favoritism or cronyism or whatever, and all sorts of people saying whatever they want. So maybe that's something we look into. I think the like getting questions in a hat at the meeting, and I know this is something like we talked about with Joanne, the last one, you have to like vet those things on the fly then, because we can't necessarily just take any question someone writes on a piece of paper and then read it out loud. What if it's wholly inappropriate? And then who's deciding that it's inappropriate and it's being done like that in the moment? So if we had a mechanism to maybe collect questions ahead of time, they could be kind of, maybe the board could even review all those questions, even if there are inappropriate ones. We could see them at that time where they're not being asked in an inappropriate time. I mean, if there's like something that shouldn't be there, then yeah, but if it's like, and then we could like, as a board or the N&E committee or whatever, could create like a set of questions, or the consultant, if we found that was a viable path, could help like form questions off of the questions that were submitted, kind of thing. So there's not like loaded, leading, biased questions coming from people. And it's kind of more standardized, I guess, in a way. I don't know. I don't know the solution either, but that was just a thought.
I would like to suggest that we just go ahead and approve the N&E manual, but then Rob can bring back suggestions. We can discuss those details again before forum. But that would allow you to go, we would be able to go ahead and approve this manual and you can start working on it.
Feedback. We have a meeting on Monday night, so we can discuss it.
Rob, hearing, there's no more. Rob, so do you want, Ray, go ahead.
Yeah,
Right.
so Rob, do you need approval to print this thing so you can add all the corrections?
I'm sorry, I
in the right
I started
format?
speaking earlier.
Yeah.
I move that we approve the proposed revision to the 2024 NE manual.
I second
Yeah.
Get it done. 3 minutes to 10.
Well,
My cats.
so you guys are, like you're saying, I know the motion's on the table already. It's been made and seconded. We're okay with approving the manual, even though we want corrections done?
You'll come back with that after he talks to his committee. So he'll just bring it back and we'll have it, then we'll finish discussion on that.
I think it's just that one section.
Maybe come back for more. I got
So,
it.
so let me describe what I think you're asking. We could go forward and approve this revision. And I'm being asked to get some ideas from the committee on how we can ensure that there's improvements to the candidate forums so that there are streamlined questions and they are good, meaningful. They're good, meaningful questions, right?
And additionally, you're currently looking at a parliamentarian. You mentioned that earlier, right? And then maybe they might have an idea for like that third-party person that might come and facilitate,
Absolutely.
moderate, or whatever you want to call it, MC the N&E. Okay. Okay, so the motion on the table was a request that the SVCA Board of Directors approve the revised N&E manual. So the motion is same thing. Move that the SVCA Board of Directors approve the revised N&E manual. We had a motion. Who made the motion? Rob?
Robin Ray made the motion.
Robin Ray. All in favor? AJ?
I'm abstaining. I didn't get a chance to review all of it at all, actually, so.
You, are you with us?
He's approving it.
Oh, he is. Okay. Okay, so we have, that's all in favor, one abstain. AJ. Okay, you've been approved, Rob. Thank you.
Thank you, everyone.
Okay, moving on to our last. No, we're not. We got 9. Excuse me. Moving on to 9E, it's a tennis court change order.
Get home.
So because this request was not provided in advance of the meeting, I'm going to go ahead and read it. The purpose of this request is to get additional funding for the tennis court resurfacing project 9723.05. Back in March, the SVCA Board of Directors approved funding for the tennis court resurfacing project in the amount of $302,615.38. That project is now underway. One of the first tasks in the project was to have the engineer identify the areas of asphalt to be repaired. In doing so, it was discovered that the damaged area of asphalt is much larger now than when the site was first inspected. When the engineer completed the layout, it was determined that 2,950 square feet of asphalt needed to be replaced. The original estimate included funding to replace 1,490 square feet, leaving a difference of 1,460 additional square feet. 1,460 times the unit price per square foot for asphalt of $17.25 gives you a total of $25,185 needed additional. You put tax on that, and the total additional cost is $27,401.28. The schedule for this project has been in place for many weeks. If the additional funding was not approved immediately, the delay would mean that the project could not be completed this year. To avoid this outcome, the executive team approved the additional funding for the project. Additional detail regarding the time sensitivity of the decision is found in the attached memo from P&W Services. Basically, if the asphalt doesn't get laid or didn't get laid yesterday and today, then the paver, the contractor couldn't come back quickly enough because they're all booked up. He couldn't come back, they couldn't come back quickly enough to get the asphalt laid early enough so that it has a curing period before the top coating can be put on. And so it was just a scheduling nightmare. The executive team was able to respond in the moment. They evaluated the memo and gave me approval for this change order. So the request at this time is that the SVCA Board of Directors ratify the decision of the executive team to approve an additional $27,401.28 for project 9723.05 tennis court resurfacing.
Questions?
No, but I just have a comment.
Okay.
Lori and I sat down and did the math just for everybody out there, including the membership. It'll bring the total cost of the project in at $330,016.66.
Thank you, Linda. All right, so the motion on the table is that we move that the SVCA Board of Directors ratify the decision of the executive team to approve the additional $27,401.28 in funding for project number 9723.05 tennis court resurfacing.
Second.
All in favor? Stu? Yeah, okay, that's unanimous. Thank you, guys. Meeting adjourned at 10:04 p.m. Sorry for the long meeting, but I really thank you all. And thanks for staying so long.
Thank you.